So you want to know, what is a patent? Let me explain it to you. A patent is a grant from the government. It gives you, the patent owner, the exclusive rights to make, use, and sell the patented invention in the jurisdiction where you get the patent. Now, patents are national in scope. They only protect you in the country where you get the patent granted. So a US patent only protects you in the United States. Anyone who makes, uses, or sells the patented invention in the United States, without your permission, you can sue them for patent infringement. So let's take the example where you have a patent in the United States, but you don't have one in Japan. Someone could make, use, or sell the invention in Japan, and you could not sue them for patent infringement. If they tried to sell that invention in the United States, then you could sue them for patent infringement in the United States. Anyone who distributed the product in the United States could also be sued for patent infringement. The other thing you have to understand is simply because you don't have a patent in Japan, that doesn't mean you can't sell the product in Japan as well. You can. You could sell the product in Japan, you could sell it internationally if you like, and you would have an exclusive right to sell in the United States. So how do you get a patent? Well, the first thing you have to do is you have to talk to someone like me. I'm a registered patent agent and also a patent lawyer. What we do is we prepare a patent application based on the information you provide us. We get the drawings made, we write up the description, we write up the claims. You review that application to make sure it's accurate. That application is then filed with the patent office that you want patent protection in. The patent office accepts that application and they give you an application number and a filing date. Eventually, the patent office will examine that application in detail. They'll make sure that the forms are all correct. They'll make sure that all the parts of the application are included. And then after a period of time, they will actually do a detailed search of their patent records to determine if there are other types of inventions which are similar to your invention. They'll review those prior patents and prior documents and compare it to your application, and if they have issues with your patent application, for example, if they think that your invention is obvious, then they'll let us know. They'll send out a report pointing out any issues that they find. We, of course, have an opportunity to review that report and reply to it if necessary. We can reply to that report by redrafting the application or submitting arguments as to why you should be granted a patent. When the patent office is satisfied with the state of the application, when we've answered all of the patent office's questions, when we've answered all of their concerns, then the patent office will grant a patent on the application. Now, how long does it take to get a patent after you filed your patent application? Well, it really depends on the facts of the case. Realistically, though, you should be looking at least 12 months to process the application after it's been filed. And in most cases, you're looking approximately 2 to maybe 3 years to be granted a patent on your application. But what if you want patents in many different countries? Well, that's pretty simple. We could file a patent application in the first country, say the United States or Canada, and then file corresponding applications in other countries as you desire. We have a limited time, usually about 12 months, to file those other applications and still claim priority from the original first filed patent application. So let's take the example of filing a patent application on January the 2nd. You file that application with the Canadian Patent Office. By January the 2nd of the next year, hopefully you would have filed all the patent applications in all the other countries that you wanted. Like, for example, a United States patent application, a German or a Japanese patent application. All of those foreign applications are essentially backdated to the date of your first filed Canadian application. So how do you enforce your patent rights? Well, essentially, there's two ways. While the application is still pending, that is to say, before the patent is actually granted, you can't sue anyone for patent infringement, but we can send them cease and desist letters, essentially threatening to sue them when the patent is granted, unless they stop. Of course, after the patent is granted, you can actually bring a lawsuit at any point. So that's it in a nutshell. That's what a patent is, and that's how you get one. It's pretty straightforward, but it can take a fair bit of time, and yes, it does cost a fair bit. So if you like this video, click on like, feel free to comment, and please subscribe. There'll be a lot more videos on a lot of different topics relating to patents and intellectual property. Thanks for watching, and feel free to call if you have any questions.